In our first episode, we learned that a set of people called directors will manage the affairs of the company, right? Now let's look into the legal definition of a director under the Companies Act 2013. Section 2, subsection 34 of the Companies Act 2013 defines the term director as a director appointed to the board of a company. Now, what is the meaning of board? Section 2, subsection 10 of the Companies Act defines board of directors or board in relation to a company as the collective body of the directors of the company. That is, the directors collectively are referred to as board of directors. Now let's look into appointment of directors. The thumb rule is that any director of a company shall be appointed by its shareholders in an annual general meeting, that is the meeting of the members. However, additional directors are such directors who are appointed directly by the board of directors of the company. However, their tenure is only up to the date of next AGM of the shareholders, which means ultimately even these additional directors shall be appointed by the shareholders in their AGM. Now let's understand various types and categories of directors. Additional directors under section 161 subsection 1, alternate director under 1 subsection 2, nominee director under subsection 3 of section 161, executive and non-executive directors, managing director under section 2 subsection 54, and finally independent directors under section 149. Additional directors are those who are appointed directly by the board of directors of the company whose tenure is only till the next annual general meeting of the company. We just saw how an additional director is being appointed. Then comes the alternate director. Alternate director is a director who is alternate to an existing director in a situation where the existing director is absent from India at least for a period of 3 months. So that's the only situation where we appoint an alternate director. Then comes nominee director. A nominee director may be appointed by the board where such a director is nominated by any institution, and that can be pursuant to terms of any law or even by pursuant to an agreement entered in with such institution. So usually where institutions fund the companies, a nominee director will be nominated by such institutions. Now, the concept of executive and non-executive. Where a director is an employee of the company, such a director is termed as an executive director. And where a director is not an employee of the company, such a director is termed as a non-executive director. Now coming to managing director. A managing director is such a director among the board who is entrusted with substantial powers to manage the affairs of the company. So such a director is termed as a managing director. And finally, independent director. Section 149 subsection 6 identifies a criteria for independence. A director who meets all such criteria with respect to a company is termed as an independent director. So these are several types and categories of directors. Every director of a company has got a fiduciary responsibility primarily towards the shareholders and also towards all other stakeholders of a company. By fiduciary responsibility, it means that the director shall act in the best interests of the shareholders and other stakeholders of the company. So, can a shareholder be appointed as a director? The answer is yes. In fact, we did discuss in our first episode that a shareholder can be a director as well as an employee, but in their individual capacities, their roles and responsibilities will be different. Now that we have learned the concepts of who is a shareholder and who is a director, let's try to understand in our next episode as to what is a general meeting and what is a board meeting. And also, we will learn on the concepts of ordinary resolution and the special resolution in our coming episodes. Do subscribe to Virtualaw and stay tuned to more explainer videos on the company law. Thank you.